Scale, you can raise it. You see, you raise the frequency.
Yes.
You see, and so someone who's
Has, can you hear me? A'udzubillah minasyaitonir rajim. Bismillahirrahmanirrahim. Assalamualaikum and a good afternoon to everybody. I'm Zakri. I'm the General Manager of Strategic Services of the Malaysian Employees Federation. I would like to welcome all of you to our first ever MEF free webinar on the social media platform. As you are aware that this event will be broadcasted on YouTube, and we hope that you will join us and will benefit from our sharing with you on a very important topic on the Employment Act, on the amendments of the Employment Act, which is expected to be implemented on the 1st of January 2023. So without further ado, before we get to the meat of our discussion, I would like to invite our Senior Manager of Membership, Puan Haslena Ismail, to share with you a bit about MEF and what we do. So, Puan Haslena, the floor is yours.
Okay, thank you very much, Encik Zakri. Ladies and gentlemen, how are you? Good afternoon. Assalamualaikum warahmatullahi ta'ala wabarakatuh. I'm Puan Haslena, and I will be sharing with you some information because when this webinar is featured on the social media, I believe most of the participants are interested to know what MEF is. In fact, for this coming half an hour, I will be explaining to you, elaborating to you on our role, functions, and services. For those of you who are already our members, please treat this session as like it is like a refresher to you, because some of you who have been our member, probably you just need to know what are the new things or even the highlights of our services, in which you just allow me to share my presentation slide with you. Yeah. Right, so shall it be this one? Hold on, please. Okay, so this is an overview of MEF roles, functions, and services, as I mentioned to you. This is just a preamble before you meet up online or virtually with our senior consultant, Mr. Goh Seng Wing, who will be presenting to you later on the EA Amendment Act, which is, I think, the attraction of today's webinar is that, yeah. Anyway, just berkenal-kenalan dulu dengan MEF, yeah, what we do, our functions, roles, and services. All right. Probably most of you have seen us appearing in the mass media, yeah, on various issues, as long as the issues are actually of the interest to the employers, yeah. So MEF, you can treat us as expressing or pointing out the being the reference for the views of employers in the country, yeah. All right. Okay, so many newspapers, printed newspapers, electronic media, even like any other form of new media right now. Yeah, okay, now. So we also express business needs of the employers, yeah, particularly the private sector employers. Okay, in fact, today, this is an additional slide which I just put in today. The thing is that it appears in today's e-newspaper, Star newspaper, where this is something which MEF expressed our concern when the government decided to implement the minimum wage policy, which we highlighted to the fact that MEF, we did a survey among our membership, and we found out that the policy has resulted in extra costs. That's what our members say. And the thing is, about 77.4% of the companies which took part in our survey said that they actually do not want to pay higher wages. The thing is that it impacts, to the micro and small, medium enterprises in implementing the new minimum wage, for which for the many employers in the MSME category are hoping for more financial assistance in this coming budget 2023 announcement, which is to be announced somewhere in early October. Yeah, so this is something which is panas. I mean, very, very likely in which in today's newspaper it came out. Yeah, all right now. Okay, even in the Chinese newspapers and so on. Okay. So for MEF, like Dato' Hadi Syamsuddin Bardan, our executive director is not kata apa yang tidak appear. I mean, he always appear in the newspaper, in the apa tu, electronic media. For example, like for Money Matters program, quite a number of times that he appeared. Yeah. Okay. Now, right. So what is MEF? For most of you, you know that the word Malaysian Employers Federation. So of course, we are an organization being established to assist employers in the country. Okay. Employers here meaning in particular, specifically, it is private sector employers. So kalau let's say your company is having some issues pertaining to katakanlah, you want to take action against your employee, maybe habitual latecomer or maybe abusive of sick leave. Contoh, okay, so before you take any action, okay, it's best for you to know what are the things that are stated in the employment, in the labor laws, okay? Do not take action based on emotions or even let's say, you know, if your boss says, I want you to sack that particular employee tomorrow. So as an HR practitioner, you can't do that. You have to know, you know, the processes and what are stated in the labor laws. Yeah, okay, now, so MEF is actually an organization where HR personnel seek professional assistance from us. So how to take action, you know, when to take action, why do we have to give contohnya apa tu, warning letters and whatnot. Yeah, so I am not the person who is good in this, in which Mr. Goh and his team is the professionals who are dealing with employers, in particular the business owners, the HR personnel, in dealing with all these issues. Yeah, okay, now. Right. So to sum up what MEF is, we are actually the central organization of private sector employers in Malaysia, and we get recognition at the national di peringkat kebangsaan, regional di peringkat serantau, which we relate to ASEAN and Asia Pacific, dan juga at the international levels, which is we are a member of IOE, for example, which stands for International Organization of Employers. Yeah, all right. I will explain to you quickly on these coming slides. Okay, in May 1959, we were established, and tahun ni sudah 63 tahun the establishment of MEF, right? And when we first started, it was just about 66 ordinary members. That was way then. I mean, 2 years after Merdeka lah. Tak sampai 2 years lah, about setahun lebih. And then up till now, year 2022, kita ada around 6,000 plus ordinary members and 28 association members, okay? Right? And we also have established our regional offices because Malaysia, for MEF, the HQ is in Petaling Jaya. And then we also have members in the northern region, southern region, east coast region, Perak, Perak as a state as it is, Sarawak and Sabah offices. Yeah, right. So when we say that we get recognition at the national level, as you can see in these coming 2 slides, you can see the MEF, we have representatives in these various boards, yeah, government boards. Okay, these boards actually comprise of representatives at tripartite level lah, meaning ada representative from the government, yeah, representative from the employers and representative from the employees. So for the employers representative, MEF is there, yeah, to represent the views, the opinion, and the concerns of employers in all those issues that are being discussed in these various boards. Yeah, misalnya NLAC, Wages Consultative Council, EPF Board, MPC Board, NIOS dan sebagainya. Right. Okay, this one sambungan ya. We also have representative in SOCSO Appellate Board dan sebagainya. Yeah, right. Okay, when we say that we are getting recognition at the regional level, as I mentioned much earlier, at the ASEAN level, yeah, we are a founder member of ASEAN Confederation of Employers, and at Asia Pacific level, we are also a founder member of CAPE. Okay, these two regional organizations gather ataupun unite all the employers organizations within ASEAN dan juga Asia Pacific. Ya, jadi banyak kerjasama, toleransi dan juga persefahaman ya di kalangan employers organizations in ASEAN dan juga Asia Pacific when we have our forum and meetings ya at these levels. Okay, now we are also a member of IOE, as I mentioned much earlier, and every year MEF, together with the Minister of Human Resource, as well as the representative of employees, namely QPEX and NTUC, together kita bincang all those labor issues in Malaysia via the International Labour Conference, ILC, right now. So currently, our president is Dato' Dr. Syed Hussein bin Syed Husman, yeah, and upon his appointment way back in 2020, yeah, after the election, he was also elected mewakili Majlis Pekerjaan Negara, and among others, and he was also appointed as member of Pemuda, yeah. Now, okay, now. When we say that we play a role, an active and important, significant role as mewakili majikan, we also make ourselves engaged in the various government dialogues, and we also make representation on various matters as long as it concerns employers' business interests dan juga anything yang maybe impact, the employers dan sebagainya at the national level. Jadi macam contohnya, we put up memorandum to the Ministry of Human Resources, even at MITI, Ministry of International Trade and Industry, dan juga other ministries, umpamanya misalnya on katakan on Tibet, okay, we also got ourselves involved. Jadi all the various ministries, they received participation from MEF, either by invitation ataupun we put up very strong memorandum to make sure that the business interests of employers, in particular the private sector employers, are highlighted and heard by the various ministries, be it the government wakilah, the government jabatan kerajaan dan sebagainya. All right, now, so when we say that we are an association sebenarnya for employers in the country, so what do we provide the services to our members? Because what is an association without membership? Jadi for MEF, we are a registered society di bawah Registrar of Societies Act. Okay, now, jadi for MEF, sebagai sebuah pertubuhan majikan, we get members, we get members, companies register with us by paying annual subscription to get our services, okay? Jadi these are the 5 main services that we provide to members, Number 1 is IR, which is the industrial relations, And then we also have big data, research and information, Thirdly is IT. Fourthly is OSH. And last but not least is on training. Okay, now, you must be wondering, okay, I'm not a member of MEF. Okay, let's say if I were to join MEF, what do I get? Is every services free ke? Something like that. Some people thought, you dah bayar subscription, everything is free. Tidak, we don't sweet talk to you, okay? Because we provide professional services. Jadi being an association, we provide services which sometimes the services are free-based. Sometimes the services are fee-based services. Okay, now, I divide into 2 main categories here. The free-based services, these are the things that you can get if you join us as a member. Okay, free advice, free guidance by phone, email, fax. And then you will also have access to our members portal in MEF portal. Okay, you will be given user ID password where 4 persons within your organization, not only the HR manager lah, HR executive personnel, 4 persons within your organization can have access to our members portal. Okay, you will be getting email blast very regular. Yeah, email blast ni containing the information on kalau katakan there are any new announcements by the government, ya, elaboration of contohnya baru-baru ni saying that the Minister of Human Resources menyatakan the EA amendment ni to be effective 1st January instead of 1st September kan. Jadi we will come up with we will issue circulars lah. Jadi you will be getting email blast regularly, even on our training courses dan sebagainya. Alright. And then lagi satu, okay, mark the word there, simple written opinion on IR HR issues. Okay, I put the word simple because kalau katakan you are the HR practitioner of that company and you have inherited surat yang maybe your HR manager prepared 10 years ago. Something like that, maybe surat to offer, offer letter of a person. Contohnya lah, maknanya you already have that form of letter. So you want us to look, to review, okay ke? Is it, is it accordingly or something like that? Or maybe can I just, get your MF opinion just to change ke? Itu simple written opinion lah. Kalau kata you want us to draft daripada A sampai Z and then there will be some fees charge lah. Okay, jadi simple written opinion boleh, it is free. Okay, now lepas tu monthly meetings. Monthly meetings normally, due to COVID all that, kita memang fully online. Jadi this is something which for you, but in particular the HR practitioners, don't miss this opportunity to attend our monthly meetings, because monthly meetings for MEF members, it is a very useful platform where number one, you get yourself acquainted with the latest contohnya apa tu, kalau any new regulations ke, amended regulations ke, you will be briefed and there will be a discussion there. Okay, lepas tu yang kedua, for you, katakanlah you yourself, you are actually a degree holder in HR, tapi that was maybe about 5 years ago. Jadi there are new things you need networking lah for HR practitioners among our membership in our monthly meetings. Yang keempat, let's say your company has any products or services that are of importance that you would like us to know, tapi this one you will have to write into the secretariat to seek slot ke something like that. Kalau kita will view and consider lah, kalau kata benda ni merely purely nak meniaga ke apa benda, we don't allow. Tapi what is there, the interest for our membership, then maybe we can consider giving you slot, maybe half an hour, something like that lah. Jadi this is the monthly meeting. Lagi satu, let's say if there are from the floor requests for katakan a particular issue to be briefed, contohnya katakanlah, okay, yang ni, this one is on EA amendment contohnya, can MEF arrange for someone from JTK Labour Office to brief us on this? Okay, kita boleh arrange for the speaker from the respective organizations to come and brief members on that issue. Macam tu lah. So those will be the happenings during the monthly meetings. Jadi our monthly meetings ni are scheduled ahead. Yeah. Jadi when you are our member, you will be grouped according to your location. Katakanlah you are in the Klang Valley, either if you're in KL, you will fall into the Central Region Group. Yeah. Jadi Central Region Group ni kebanyakan in the Klang Valley lah. Alright. Jadi Central Region Group meeting dia every 3rd Wednesday of the month. Kita schedule ahead macam tu. Unless kalau ada something happen lah, misalnya it's public holiday kan, kita tukar. Okay, macam tu. Even if you are in the Klang Valley, contohnya katakan you are in Putrajaya, we also have another group which we call it Shah Alam Putrajaya and Klang members, where the meeting is scheduled every second Tuesday of the month. Macam itulah. Jadi let's say if you were to miss our meetings, need not worry, because the minutes ke apa will be provided to you in our MEF members portal. Okay, now, so tadi tu saya rasa saya dah sentuh access to MEF members portal. 4 persons within your organisation can have access. Jadi tak ada excuse lah, misalnya kalau kita bagi satu je, and then the HR manager is on maternity leave. So no one in your organisation will know ke apa-apa. No, tidak, 4 orang boleh ada access. Okay, and then this one, because of the MCO, the PKP, all that, kita ada WhatsApp group. WhatsApp group ni we have to limit it. Contohnya one company, 1 orang saja yang kita boleh allow, because kadang-kadang satu company sampai 4-5 orang nak masuk. I rasa kita punya IR consultants pun they have limitation in their handphone. Jadi kita allow one company, one number to be there in our WhatsApp group. Now, itu free. Yang fee pula, okay, of course, if let's say your company you have a court case. Court case here meaning labor dengan industrial court case. Dua court ni kita boleh represent you without you having to garu-garu kepala, cari the best IR lawyer in the country, tak payah. Because to assure you that MEF, kita punya IR consultants, they are qualified lawyers, and this is what they do day in, day out, itu kerja dia orang. Jadi the labor punya matters all within your fingertips lah. Jadi we can represent you at court cases, labor court dengan industrial court with a minimal charge. Okay, minimal charge dekat sini, you do not have to worry. Walaupun it's minimally charged, we do not compromise on the quality. Because within our IR department, kita ada group of people who have very much experience. Even we have in our team, kita ada ex industrial court chairman pun juga ada dengan kita, dan kita ada qualified people who have very experience in the industry. Lepas tu dia join kita. Okay, jadi jangan risau. For corporate representation, you can rely on MEF. Now, another one is consultancy packages. Consultancy packages ni something like if your company would like to produce a handbook, contohnya, right? A handbook ni we can start from scratch, ataupun your organisation already have a handbook you would like us to review. Jadi based on the complexity of the task, we will give you a quotation dulu, whether it's agreeable to you or not. Okay. Lepas tu ada juga yang handbook ke, you would like us to translate daripada English ke BM dan sebagainya. It is within the consultancy packages. This one you can always ask our consultants, discuss with them what is it that you want, then we will give you a quotation. Okay, now lepas tu seminars, webinars, conferences. Okay, we are a registered training provider with HRDC. Jadi our courses are claimable from them. And biasanya this particular service we buka to members and non-members. In which kalau members of course ada discount as compared to non-members. Right. Lepas tu training, we also have an academy where later on I will touch in my future slides, dan juga kita come up with publications. Jadi I hope you're clear. Free and fee-based services. Now, for IR, this is to sum up, kita bagi advisory, opinion via phone fax, face-to-face. Better for you to come to our office premise rather than I would like MEF consultant to come to our premise. Dekat mana tu, something like that. So, other charges will be imposed lah kalau you would like our consultant to go to your premise. Kat mana? Oh, my office is in Port Klang, contoh. So, adalah, the travelling, and then consultation at members' premises, the charge will be imposed. Jadi, it would best if you can come to our office and make appointment to see our consultant here. Right? Okay, now, and then tadi WhatsApp group kita ada court representation and conciliation at our department also we do. Okay. For information, conciliation at our department, you cannot bring your lawyer in. Only MEF is allowed under IR Act. Okay, and then we also have monthly meetings. Okay, now I move on to research and information services, which is tadilah big data, all that lah. So we come up with survey publications, as I mentioned to you tadi tu, the one which appeared in the Star newspaper today tu, based on our whatever our president cited, quoted tadi, based on our findings from our survey among our membership. Yeah, okay. Normally kita akan minta pandangan ni. We also have quick poll with our membership. In our website. Okay, we also have mini library services, and we also have economic data, labor data provided to you. Okay, macam ni contohnya MEF salary survey for executives dengan non-executives. This is a yearly affair. Every year kita akan buat survey ni. Okay, the survey books are very useful because kalau kata you as a company, you would like to know what is the salary trend for certain benchmark position. Contohnya for executives level, kita pun ada satu volume for executives. For non-executive, kita base our tabulation and our, we call it analysis based on by location, by industry, by years of experience dan sebagainya. Okay. For 2022, kita tengah tabulate sekarang ni, in which biasanya in the month of November, we will come out with the findings of the survey for that current year, for that particular year, and kita pun ada element of prediction, what will be the payment for bonus, will be the increment percentage for executives dengan non-executives. Jadi ini this is a very useful information in which Ministry of Finance, Bank Negara Report, even MIDA kan, okay, they quote the findings from our survey books. Okay, now yang lain-lain tu misalnya kita also conducted macam misalnya fringe benefit survey. You look at the 2020 lah, because fringe benefits tu kita tak berubah every year. Jadi kita buat once in every 3 years, something like that lah. Okay, and then yang publications yang lain. Now, okay, for you, the HR practitioner, this is a very, very useful book in which I would always encourage for you to have this book at your desk in your office, because you see, these books, okay, for information, our books are not available at bookshops. Okay, only exclusively available in MEF. You look at the one in green cover, Practical Guide to HR Management. Okay, it has come out in the 2nd edition already. Buku ni ialah actually is a compilation. It is a guide actually, because me being in the membership, kita selalu juga dapat phone calls, people ask for, Puan, MEF ada contoh tak, ada template tak, surat tu, surat ni, all that. Kita tak boleh bagi because it is a highly PNC for companies. Jadi sekarang ni, what we have decided is we come up with practical guide. Jadi for those of you who like to see templates, contoh-contoh surat, all that, and then bear in mind though, it's practical guide. This is practical in nature. Bukan kata ni it is macam buku teks punya kind, you lepas tu you nak buat, you implement tak boleh. No, this is a practical guide. So you better have this book. Jadi sekarang biasalah members harga lain, non-members harga lain. Okay, later on nanti kalau ada berminat boleh contact MEF. Right now. Okay, now I move on to training. Kita ada training academy. We call it MEF Academy. It is actually a subsidiary of MEF lah. Jadi kita, as I mentioned, kita registered with HRDC. Okay, the type of service, the type of courses or programs that we do. Okay, sama ada we do in-house, in-house, we customize to your needs. Kita boleh merge 2-3 courses together depending on the training need analysis, which our consultants will sit down with you to discuss. Ataupun we come out with public courses. Okay, dua-dua mode ada, dan juga kita pun ada physical dan juga kita ada online. Jadi ini, these are the orang kata the spectrum, the entire spectrum of HR management that yang kita offer lah. Contohnya continuous improvement of development of HR management, HR development, this type of courses kita provide. Lepas tu on industrial relations is of course MEF is IR, IR is MEF. Okay, we also have OSH training. We also have our OSH consultant here in MEF who also does OSH audit right now. We also collaborate with industry specialists where you can see that we have macam misalnya kita buat program. Contohnya lah, kita ada buat contohnya webinar on taxation all that lah. Jadi kita akan panggil the tax expert lah, industry specialist to come up with programs for you. Even on on akta yang SPRM all that, we come up with programs. Yeah, we also have academic programs, diploma and certification courses, dan juga kita buat conferences and seminars. I think last week we just had our national conference, which was a success. Yeah. Okay, now. So on membership, okay, how to become our member? How to become MEF member? Okay, this is a quick glance for you. Kita ada two types, ordinary member, association member. Kalau you a sendirian berhad atau you are a business owner, you are an enterprise, you can join us as ordinary member. Ordinary member ni pula terbagi kepada dua. If you are a single company or you are group. Group ni applies to company having subsidiaries. Yeah, having subsidiaries. Tapi you punya HR is centralized to your holding company. Then you can join as a group. Jadi at the end of the day, how much you've got to pay is based on head count. Yeah, alright now. Lepas tu murah je, entrance fee kita 500. Just last 2 months kita ada campaign entrance fee waiver. Jadi kalau any one of you would like to join MEF, if you would like to get this waiver punya ni, we can still apply lah kalau ada permintaan. Okay, anyway, annual subscription is based on the total head count of your organisation. Kalau kata head count you below 100 orang, below 100, you ada 5 orang ke, you ada 25 orang ke, you ada 80 orang, is still RM1,000 for 1 year. 1 year here means year. RM6,000, RM6,000 tu plus for company having 3,900 employees lah, lebih kurang macam tu. Dia bayar RM6,000 je. Walaupun dia ada 20,000 employees, dia bayar RM6,000 saja. Tapi yang cantik ni RM1,000. Kalau RM1,000, we follow calendar year, divide by 12 months, maknanya sebulan, with all the professional services, only RM83. Just bear in mind. Okay, tapi sekarang ni is towards September now. Kalau after this session, you try to convince your management, kata, boss, why don't we become MEF member? Kita cuba for 1 year, see how it goes. Yeah? Jadi sekarang ni, you join kita September, the amount you pay RM1,000, campur 500 tadi, RM1,500. It is actually for September 2022 sampai September 2023. Jadi for 2023, it will be prorated sampai September sampai December. Berapa bulan je you kena bayar kan? Okay now. So that's how we calculate lah. Alright. Jadi again, kalau apa-apa boleh tanya dengan kami di membership. Okay. Ini association member ni is quite complex tapi jangan risau. Macam ni je lah. I just bagi you some information because kita ada a few categories here. Kata kalau within your industry, you are under the umbrella of any industry group kan? Okay, nanti you boleh contact kami akan explain, how to become association member, yeah? And then because ada benefit juga, you are a member under that particular industry group, ada some discounts will be given. Okay, now ini contoh-contohnya lah, kita ada kat sini, insurance employers, yeah? Banks, hotel employers, chamber of commerce and industry, timber, plastics, Okay, now ini yang currently our association members. Kita ada even agricultural producers, kita ada Persatuan Pengusaha Restoran Muslim dan sebagainya. Right now, okay, as long as ordinary membership and association memberships are concerned, kita ada steady growth lah, walaupun orang kata apa, slow and steadily lah. Okay, macam tu Okay, now, so kita cover our employers, being our members, dia punya employees in number come to about 3 million of private sector employers, employing about 3 million employees. That is within our membership lah. Okay, now. And then by location, okay, tadi you can see lah, kita ada span across the country. Jadi kita ada Northern Region, Perak Office, Central Region, Southern Region, East Coast Region, East Malaysia. Yang others tu you see kita ada members di Singapore juga lah. Alright now. Jadi this is kata our members are scattered all over the country. Now, okay, jadi ini lagi satu, new member incentive scheme, which is still berkuasa lah. sampai 31 Disember. Okay, how this scheme works is like macam ni. Kalau kata after you hear, you dah faham how MEF, it is very beneficial, useful to employers. Katakanlah a friend of yours from another company, diorang tengah nak cari alamat how to get advice all that, you buka mulut lah. You buka mulut, you cakap, that day I heard about MEF. Contohnya, why don't you contact them? Kata kalau your company, your friend's company join kita, we will ask them who is the introducer. They will say that you are the one who introduced. Kita reward you RM450. Lumayan kan? Okay, now you can start doing it. Tapi kalau kata your company join, you tak boleh dapat lah. Get a friend of yours to perhaps be the introducer, then we will reward that person. Okay, anything, terms and conditions apply. Any inquiries, that is the MEF membership at mef.org.my, or that is the phone number for you to contact. Yeah, all right. Now, I'm about to end my presentation. Thank you so much for your attention. Anything, please visit our portal. And then we also appear on social media. And anything on membership, tolonglah. Okay, you can always contact that email address. Ataupun this is the number lah, 7955-7778. Yeah. So we would be glad to explain to you, to elaborate to you, to convince your management on how we can assist you to become a good employer lah. Yeah. All right. Now, so I pass back to Encik Muhammad Zakri to roll the floor. Thank you.
Thank you, Haja. I think
Thank
that was
you.
a very comprehensive presentation by Haja Haslena. I think I hope you all are very well informed about MEF activities and the benefits of joining MEF as members. So for our next item, I think which is the hot item, belum start ni dah ada banyak dah soalan ni on the amendments to the Employment Act. So without further ado, I now, with all due respect, I invite our senior consultant of industrial relations, Mr. Goh Seng Wing, to deliver his presentation. Silakan, Mr. Goh.
Thank you very much, Encik Zakri. Thank you for the kind introduction. Ladies and gentlemen, so this what you are waiting for, my presentation today on the amendments to the Employment Act. These are the hot issue. One thing good in the sense that the minister had, come up with an announcement on the postponement. Otherwise, ladies and gentlemen, it will be on 1st September. That is, in another 2-3 days time. But fortunately, or maybe unfortunately for some of you, that it is postponed to, 1st January 2023. Fortunately for employers, delay is a deferment on the payment of increased costs. Unfortunately, normally for employees that they are actually getting the benefits, 4 months later rather than 1st September. Yeah. So, ladies and gentlemen, what is very interesting for you to know is the amendment to the word employee covered under the Employment Act. The Employment Act is applicable to Semenanjung, Malaysia. Yeah. If you are in Sabah, if you are in Sarawak, Employment Act is not applicable there. However, Sabah Labour Ordinance or Sarawak Labour Ordinance will be, applicable, respectively in East Malaysia. But then don't be too happy for some time, because the Sabah as well as Sarawak Labour Ordinance are also being amended. And the amendment are normally most likely in accordance with what is being amended in the Employment Act for employee. good news for employees is that any person who is an employee who is working under a contract of service, who is given a letter of appointment to be employed, he is covered under Employment Act as spelled out, as spelled out in the first schedule of the Employment Act, meaning that high-ranking management staff, CEO, COO, who are actually not covered before the amendment with effect from 1st January 2023, they will be covered under Employment Act and protected under Employment Act. However, this group of high-ranking management staff and whose wages exceed 4,000, no doubt they are covered under Employment Act, but then as long as their salary exceed 4,000, they are no more covered under certain section like Section 63, payment for working on rest day, Section 60A3, that is payment for overtime, and payment of shift allowance and payment of work on public holidays, and also termination and day of benefit will not be applicable for those who are earning above 4,000. But this limitation do not apply to manual labor. Manual labor meaning those who are involved in buruh kasar, who are earning, very much above 4,000, yet they are covered irrespective of the earnings. As long as they are manual labor, they are all the while, as in the past, covered under Employment Act. Who are manual labor? Manual labor are those who use excessively physical energy to work, and they use less of their mental energy, not like the doctor, not like the accountant, not like the executive staff, where they use a lot of mental energy. But this manual labor, of course, they use mental energy, but they use more physical energy. And in order to cover more people under Employment Act, the amount of wages, does not include commission, subsistence allowance, and overtime. So that when they earn a lot of commission, yet they are still covered under Employment Act in the respect of, for example, an executive staff earning 4,000, exactly 4,000, he can claim overtime, but then he has commission. He earned a lot of commission, but let's say his commission is 2,000, 4,000 plus 2,000, 6,000, yet still covered because the 2,000 is not to be taken into consideration for determining the 4,000. And the rest are all covered under Employment Act because they are involved in mechanically propelled vehicles like the drivers. They are supervising the buruh kasar, and they are domestic employees. So, ladies and gentlemen, for this presentation, the amendment, I put it in red fonts. And the apprenticeship contract, is those who are engaged to be trained for a period 6 months to 24 months, approved by the Director General Labour. And this is something new under the new Section 18A, whereby the amendment, guide you as to how to calculate the wages of employees who actually join bidder of the month, or who actually resign before the end of the month, or who actually took unpaid leave. To calculate all this, then there is a formula whereby you use the number of days in the particular wage period. The number of days in the calendar month. For example, if the calendar month got 31 days, you use the denominator 31 to calculate. Yeah, before this amendment, there is no guide, and many employer were thinking they use, 26 days to or based on 26 days to calculate the balance of wages. But now the law is very clear. You are going to base on the number of days in the particular wage period, or alternatively in the particular calendar month. Yeah. And well, all the while you pay your workers' wages through bank. With the amendment, you not only pay through bank, you pay through any other financial institution. And what you mean by financial institution, which is not only bank, but it is yes, bank, but including Islamic bank, it's also including development financial bank. Yeah, development bank, so that it's a wider place or financial institution whereby you can deposit the wages of employees for payment of the monthly salary. And so the minister can appoint any other financial institution for payment of salary. Yeah, and one thing that make employer more difficult to pay the workers' salary in cash. Legal tender means in cash or by check. All the while, before the amendment, you can pay by cash, you can pay by check, as long as the employee agree. With the amendment, even though the employee agree that you pay by cash, you pay by check, you still need to get, the approval. Yeah, you still need to get the approval of the Director General of Labor. Yeah, the written consent of the employee is not sufficient. Still need to get approval from DG to pay the wages of employees by check or by cash. Yeah, including that of a domestic employee. This is to ensure that the workers get their wages, accordingly through the financial institution. Yeah, the government, to what I know, do this is to ensure employees, especially the foreign workers, get the wages monthly through the financial institution. Yeah. Now, this is something, very protective of female employee. Yeah, before the amendment, the protection is only for maternity protection. Yeah, after delivery of a child, now the amendment include even before delivery of the child. Yeah, not only maternity, but for pregnancy. So where a female employee is entitled to maternity leave, yeah, and she may, with the consent of the employer, commence work at any time during the period of the, maternity leave if she is certified fit to work. So this is the choice by the employee, female employee, who having entitled to maternity leave and also entitled to allowance. There are female employees who are entitled to maternity leave but not entitled to allowance. Yeah. So whether entitled to allowance or not entitled to allowance, after having the maternity leave, she may, wants to come back. So she need to get the consent of employer to allow her to come back. And of course, the employer will ensure that she is fit to work, to ensure that she get, being certified by the registered medical practitioner. And this is very good news for female employee, the maternity protection for maternity leave, which is increased from 60 to 98 days. Ladies and gentlemen, supposed to start from 1st September. However, those who expected to deliver after 1st on or after 1st September, they have to, make good with only the current 60 consecutive days, only from 1st January 2023, then it will be 98 days. Yeah, ladies and gentlemen. Now, I have mentioned earlier that there are people, female employee, entitled to leave, but not entitled to allowance. Yeah, not all entitled to leave are entitled to allowance. Yeah, for example, a person who already got 5 or more surviving children, and now she is giving birth to the 6th child. She will be entitled to leave, 98 days leave from 1st January 2023, but she won't be getting allowance. She will get allowance for 98 days only if she has, less than 5 children at the time when she gave birth. However, all female employee, after giving birth, will be entitled to leave. That is called maternity leave. Yeah, 98 days. Yeah, currently 60 days. Yeah. So other condition that prevent the female employee who entitled to leave, maternity leave, to get allowance is that she has not worked for at least 90 days with the company. To allow her to get allowance, she must work at least 90 days with the company. Yeah, and also 4 months before she delivers, she must work at least 1 day. Yeah, so there are cases whereby new new female employee who works with the company only for a period of 60 days, short of 90 days. So she delivers, so she can get a leave. She can get a leave because she, deliver a baby after at least 28 weeks of pregnancy. However, she will not get the allowance. Yeah, and all right. The restriction on termination of pregnant female employee is a good protection. It's a new amendment that female employee who is pregnant cannot be terminated. But except for the grounds of willful breach of condition by the employee, such as she always absent from work without good reason, absent for more than 2 working days, yeah, and if she has committed misconduct, and also if the company has closed down business. For these 3 good reasons, employer can terminate female employee who is pregnant. Other than these 3 good reasons, employer has no right to terminate a female employee while she is pregnant. This is something new, yeah. So when the female employee is terminated, it is for the employer to say that I terminate her because she is always absent, breach of condition of employment. She committed misconduct, meaning she has been, committed theft in the company or due to closure. This is for the company to prove. It's not for the employee to prove. Yeah, ladies and gentlemen. So the word used is termination. In the past, it was used dismissal. The word dismissal changed to termination. Better protection for female employee so that she cannot be terminated. In the past, the word is dismissal, meaning for misconduct only. Yeah. So the word termination is a wider protection for female employee. Yeah, ladies and gentlemen. Yeah, the due recognition for domestic employees in your house. You may have a domestic employee. In the past, you call them servant. Now with effect from 1st January 2023, you call them an employee. No more call them a servant. Yeah. So this is due recognition given to domestic employee. You may want to call them domestic maid, but the Employment Act call them employee. This is something very, very serious and very critical in the sense that the working hours in a week has been reduced with effect from 1st January 2023 to 45 hours. Yeah. So meaning you have to reduce 3 hours every week for your employees, and the protection is also to protect employees working at night. Yeah. However, the law is talking about this is the law. Ladies and gentlemen, whatever I present to you are not all on amendment only. I am also presenting to you some pertinent provisions of the Employment Act. Yeah, so that you are actually well aware of the important provisions of the Act, you know, for you to comply, yeah, or for employees to benefit, yeah, so that every 5 hours work, they have to have 30 minutes break, and you cannot ask them to work more than 8 hours, yeah. And this is still there, the law, not more than 8 hours. Anything more than 8 hours or anything more than spread over a period of 10 hours, you have to pay them overtime, yeah. And of course, you cannot ask them to work more than 45 hours a week. Yeah, ladies and gentlemen, yeah, these are actually consequential amendment to the law, and the law also has special protection for employees working at night. In the past, the protection for female workers working at night, yeah, but now the protection is not only for female workers working at night, it is for all, male as well as female, protection for working at night, so that at night, between the hours of 10 p.m. To 5 a.m., that is called night work, 10 p.m. to 5, you have to provide the workers, whether male or female, free transport, as well as also pay the night allowance. Yeah, so these are good news for male employees, so that whatever female will get in the past under Section 34, which is Part 8, protection of women employees, is now given to male employees, so as to do away with gender discrimination. Yeah, shift work also, instead of 48 to 45. Yeah, so ladies and gentlemen, another important amendment is the entitlement to sick leave per calendar year, which has been increased. In the past, it is 14, 18, 22, up to a total of 60 days, which include the 14, 18, or 22, depend on years of service. With effect from 1st January 2023, this is 60 days, something in addition, yeah, to the 14, 18, or 22 days, depend on years of service. For your information, ladies and gentlemen, the benefits to employees under the Employment Act are based on their years of service. And in the Employment Act, the years of service are categorized into 3 categories. Less than 2 years as one category, 2 to less than 5 years is the second category, 5 years and above. So the entitlement to sick leave based on these years of service, annual leave similarly based on these years of service, yeah, and termination notice also based on these categories, and also termination benefits also based on these categories, which are less than 2 years, 2 to less than 5 years, 5 years and above. Yeah. The important point that I want to highlight to you, ladies and gentlemen, is the entitlement to paid sick leave based on calendar year. The word here is calendar year. If they join in the calendar year of 2022 this year in September, for example, their entitlement for the calendar year of 2022 is full 14, 18, or 22. That calendar year. If they join in November, yeah, their entitlement for November and December for the whole calendar year of 2022 is also 14, 18, 22, meaning you cannot prorate the entitlement because it is based on calendar year basis, ladies and gentlemen. So meaning that the entitlement is including the is in addition to sick leave, yeah, is normal such as total of 60 days, but additional 60 days is given for hospitalization. All right, and good news for men, but then it's not all men. It's only married male employees who are entitled. You have to be married, have to show the marriage certificate, yeah, and the birth certificate of the child to show that you are entitled to paternity leave of a period of 7 consecutive days. 7 consecutive days is 7 hari berturut-turut, start from the day that the wife give birth. and the entitlement of the paternity leave is only to 5 birth only, 5 confinement, 5 birth, yeah, 5 birth, irrespective of the number of wives, yeah. If the male employee has, let's say, 4 wives, and the 4 wives also give birth, so she can get only 4 times during the year, and the next year maybe another 1 time to make it up to a total of 5 birth only. All right, and the other condition is not only that he has to be married, he has to work for the company, for at least 12 months in order to be entitled. Anything short of 12 months, he will not be entitled, and has to notify the company of the pregnancy of the wife at least 30 days before giving birth. Yeah, ladies and gentlemen. Now, the Labor Department is very concerned about employment of foreign employee, and so the permit to allow you to employ foreign employee has been shifted from 1st January 2023 to the Labor Department from the Ministry of Home Affairs, KDN. Yeah, so the Labor Department will approve the employment of the foreign employee, and no employer shall employ foreign worker unless approval is given by the Director General of Labor Department. Yeah, so these are amendments whereby previously the first section is require you to furnish information on employment of foreign employee, but now the first section is that you have to get a permit first from the Labor Department and you inform later. Yeah, and the application for the permit, shall make in the form and manner which has to be prescribed or made by the Labor Department, and having approved and having employed, you have to within 14 days from the date of employment inform the Labor Department of the particulars of the employee you employ, and also the DG may subject to any written law approved application if employer complies with conditions that they have actually, make application upon no outstanding matter relating to any decision, order, or directive issue under this Act. Previously, the approval is by the Immigration Department, and the Immigration Department would approve permit to employer to employ foreign worker, even though the such employer has outstanding matter, even though such employer did not comply with the Employment Act, yet KDN or immigration approved. Now everything shifted to Labor Department that if you don't comply with Employment Act, don't comply with employment law, they will not approve. They will not approve. So make sure that you have no outstanding matter, with the Labor Department, no outstanding matter, even not only with the Labor Department, even with SOCSO Department, and also no outstanding matter relating to provision of workers' housing, or even provision of the minimum wages. As long as you do not infringe the law on minimum wage, you pay the foreign workers accordingly, no minimum, follow the minimum wage of 1,005. As long as you provide them with good housing under the Act 446, the Housing Act, and as long as you contribute to SOCSO for your foreign workers, accordingly, then they will approve. Otherwise, they will not approve. And if they don't approve and you engage, then you will be convicted. And of course, you must not be involved in anti-trafficking in person. And also, must not be involved in forced labor or trafficking of, person. So it's an offense to employ a foreign worker without a permit, and can be charged in court and fined 1,000 or jail for 5 years or both. So you need, as an employer, to inform the Labor Department when the employee is terminated. Terminated by the your company, or due to expiry of his permit, or due to reason that he has been deported, you have to inform within 30 days. Ladies and gentlemen. All right. So anyway, this is something very difficult for employer on flexible working arrangement under Section 60P, whereby it is for employee, your worker, and not for you, to tell them that you work from home, but they themselves apply to you for flexible working arrangement, such as to change the working hours, such as to change the workplace, such as they want to work from home, then they apply. However, it is your discretion, your prerogative, to approve or not to approve. If you don't approve the application for flexible working arrangement, then you have to give grounds. You cannot just say no, not approved, but you have to give grounds. As long as he writes to you, make an application, you shall within 60 days reply, and give grounds if not approved. Another important section is to prevent discrimination in employment. You cannot discriminate against your employee. If you discriminate against your employee, here employee meaning either local or foreign workers, on any matter. For example, you have one foreign worker who is paid higher wages, and a local worker of the similar type of job paid lower worker, the local worker will complain on this matter. So any discrimination on any matter, they will complain, and you have to, comply with the order of DG when they investigate. Yeah, when they investigate. Yeah, and ladies and gentlemen, something also on sexual harassment. Yeah, you have to at all times exhibit conspicuously at your workplace a notice to create awareness on sexual harassment. Yeah, such as you put up a notice board to say that company has zero tolerance on sexual harassment. Yeah, so that this will create awareness to avoid sexual harassment. Yeah, and forced labor, any employer who threatens, who deceives, yeah, or who forces the employee to do any activity against his will, beyond, or to restrict his movement, confine him in only one place so that he has no freedom of movement, commits an offense, and be liable to a fine of 100,000. So, ladies and gentlemen, you see some provisions which are actually relating to human rights, such as forced labor, such as sexual harassment, such as discrimination in employment, yeah, and such as flexible working arrangement, because Malaysia is actually, amending the law to avoid all these matter relating to human rights, simply because Malaysia is actually under tier 3 now of the traffic in person report, reported by the US State Department, and also being persuaded and insisted by the world organization such as the International Labour Organization, to ensure that there is no forced labor, there's no discrimination, allow freedom of movement, yeah, so that Malaysia would eventually avoid being having a trade barrier by the world bodies, by the superpower in the world like US, so that that's why Malaysia has to quickly amend the law, yeah, as required by the world body. That's why all of a sudden you can see all these provision, discrimination, forced labor all coming in, yeah. And finally, ladies and gentlemen, yeah, now when you are charged by the Labour Department for employing a foreign worker without a work permit, just to give you an example, yeah, without a work permit, then the duty of the prosecution, the Labour Department, is to prove that that foreign employee is your employee. And the prosecution, the Labour Department, has to prove that you are employer. And the Labour Department has to bring a lot of witnesses and evidence and document to prove that you have employed them as an employer and they are employee. With this presumption as to who is employee and who is employer, then, ladies and gentlemen, the burden of proof is on the company, no more on them. Previously, it's on them. With the amendment, the burden of proof is the employer. Simply by amending the law to have certain provision that just to show that, for example, you are controlling them, you are directing them, then you are an employer already. And if you impose hours of work on them, you are employer. So simple as that. No more such thing as to prove beyond reasonable doubt that you are employer. So as long as there are elements of contract of service, ladies and gentlemen, such as you provide them with the tools to work. For example, if he is a driver, you provide him with a car, or you provide him with a laptop, yeah, then this is presumed that you are employer. No necessity for the Labor Department to prove that the laptop is the company's laptop, the laptop is provided by the company, and then he has to do work on the laptop. Yeah, no. So with all these, what we call elements of contract of service assisted in the employment relationship, then it is presumed that a person is an employer and the other person is an employee. Yeah, the other person is an employee, as simple as that. Yeah, ladies and gentlemen, I would want to highlight to you that the MEF has been conducting training courses, webinar, seminar, conferences on the issue relating to amendment to Employment Act. There is one very good, seminar coming up on the 7th and 8th of September, ladies and gentlemen, and to be presented by none others than the executive director of MEF, yeah, Dato Haji Samsudin Badan on 7 and 8. Yeah, we have already, published this program in our website, and also we have e-blast this program on 7 and 8. It is a 2-day program. 2-day program of comprehensive understanding on Employment Act, the practical guide on compliance with Employment Act from A to Z about Employment Act. And ladies and gentlemen, today's program is just to introduce to you what are the important highlights on amendment, to know more about Employment Act, including the amendments, and also including the guidelines on implementing the amendment. I strongly advise and encourage you to attend our coming seminar to be presented by none other than our Executive Director, Dato Haji Samsudin Badan. Yeah, ladies and gentlemen, so these are actually presumption, and I am very happy if at all you have any questions, yeah, ladies and gentlemen, to present to me, that I'm willing to accept all your questions. Thank you, ladies and gentlemen.
Thank you, Mr. Goh. I think that was crystal clear from your side. I learned a lot also, although I've heard many of these presentations, because now it's a very panas topic, the amendments to the Employment Act. So I think for participants, for you to post questions, you can click on the pigeonhole link on the chat box so that you can post your questions. I think, Mr. Goh, maybe we can take some of these questions which have already been posted even before you started your presentation. Sudah ada soalan. So I think the most popular one is with 10 votes so far from Cheong. So the question reads, based on JTK question and answer issued on the 11th of August, if the employee works on 5-day week with 8 hours a day, the ordinary rate of pay is wages divided by 26, and the hourly rate of pay is ORP divided by 8. Shouldn't it be ORP divided by 7.5?
All right. Interesting questions. The amendment moving forward is from 48 hours, 48 hours a week to 45 hours a week. And in your question, you have said that 8 hours on 5 days, meaning 8 times 5 is only 40. 8 and 5 is only 40. Yeah, still very, very good standard of employment compared with the 45 hours. Yeah, and the formula is set for ORP, wages divided by 26 is correct, and HRP is ORP divided by normal hours of work. So your normal hours of work remain 8 hours a day. And so you have to divide by 8 hours, not 7.5. Yeah, unless you work 6-day week, that is a different matter. You are working 5-day week, 8 times 5, 40 hours. Yeah. All right.
Thank you, Mr. Goh. Here's another question. This is from the YouTube comment stream. It's not on the pigeonhole. From Vasanta Kumari. Are all the amendments deferred to January 2023 or only the working hours be deferred?
Yes, yeah, there are a lot of confusion. And when the minister announced a very generous statement to say that the amendments to the Employment Act deferred to 1st January 2023. So this is all the amendments, yeah, all the amendments as per the Employment Amendment Act 2022, which I call it Act A1651. All the amendments, including forced labor, including flexible working arrangement, including, discrimination in employment, and also, presumption on the workers and employer-employee relationship, all without exception deferred to 1st January 2023.
Very good, Mr. Goh. So everything lah, semua taruh lah, all to next year.
Sekaligus.
Sekaligus. Okay, sir. So I think the next question maybe we ask on this paternity leave. Is the paternity leave applicable to foreign workers who work for more than 1 year, where they are not going back home to home country to accompany the wife whom delivers the baby?
Very interesting questions. Yeah, this is a very bright spark that asks these questions. Yeah, and the law on paternity leave, yeah, Section 60 FA, did not mention about whether it is a foreign worker who is entitled or local worker. It talk about employees, meaning foreign or local. And it does not say that the worker or employee must go back to the home country if the wife deliver in the home country. That's sebut pun. Yeah. So as long as they can prove with the birth certificate of the child and the marriage certificate that they are married and they have been working for not less than 12 months, and they have informed the company 30 days before the wife gave birth, then they are entitled, whether they go back to the home country to accompany the wife or not. Yeah, so that is my answer.
Okay, Mr. Goh, another one on week hours. In order to fulfill the 45 hours per week, can we extend the break time from 1 hour to 1.5 hours? According to GTK, this one cannot. Why?
Well, this question, I know I also read the Q&A of JTK. They say that, the amendment is to allow work-life balance for the employee so that they work shorter hours. Yeah, work-life balance that they work shorter hours. And when they are given 1.5 hours as break time, they are given, longer hours to rest. That is work-life balance. Nothing in the law to say you cannot. So as long as literal interpretation of the amendment nothing to prevent you to give them shorter working hours and longer, rest hours. So to us, MEF, to increase the break time to 1 hour to 1.5 so that they work 7.5 hours a day is precisely okay. Take the challenge. Let them challenge you in court. Yeah, let it be a test case.
See, very good, Mr. Goh. Okay, let's okay, this is about maternity. Additional clause added that pregnant female employees are not to be terminated. What about pregnant female migrant workers under PLKS who might have violated some conditions of their work permit?
All right. They cannot be terminated unless they have committed breach of contract of employment, and also they have committed misconduct, and also when company closed out. These 3 reasons. So your reason is that she has committed breach by infringing the law on employment of foreign worker, a law relating to permit. Yeah. So if she has breached the contract of employment, then you can terminate. Yeah. So your question is a very general question, which how is the breach? How is the infringement? The infringement may be due to employer, not due to the employee. Yeah. So if you say that she has not been working with the valid work permit, it is the employer that can be charged in court. Of course, she also can be charged for being employed illegally. That is a breach by her. She won't be entitled. She won't be entitled to the maternity protection.
See. Okay, Mr. Goh, let's have a look at some interesting questions here. Non-citizens require a valid permit to live and work legally within Malaysia. If they fail before they become pregnant and have violated the conditions in their work permit, are they liable to deportation? Majikan can terminate service. I think this is similar to the previous question. Is it
similar? Yeah, this is due to breach or violated the immigration law. Yeah, that they can be deported. Yeah.
Okay. And another question related to this. Let's say a company gives an option to the employee to complete 60 days of maternity leave, but the balance of 38 days to replace with childcare arrangement leave within 2 years. Is this acceptable?
The law is straightforward, and the law talk about 98 consecutive days. Yeah, 90 hari berturut-turut, meaning you cannot break. Consecutive means you cannot break at all. So you have to give one straight 98 consecutive days of maternity leave. Tak boleh break.
Tak boleh break.
Tak boleh break, tak boleh replace. Yeah, tak boleh.
Understand. Okay, Mr. Goh, for employee whose salary, I think, is more than 4K, not subject to the first schedule. However, this amendment is not included. It's not does not include work hours. Therefore, this group of employees doesn't exceed 12 hours per day, right? Do you understand the question?
Hold on, let me read the question carefully. For employees earning above 4K, not subject to first schedule. However, this amendment is not included working hours. Therefore, this group of employee doesn't work exceed 12 hours a day, right? All right, I understand the question. So the question is that saying that this group of people who earn more than 4,000, not subject to first schedule. The first schedule, paragraph 1, mentioned very clearly that all employees under a contract of service is covered under Employment Act. So this group of people who are earning above 4K is still subject to first schedule as long as they work under a contract of employment. However, the paragraph 1A of the first schedule spell out that if this group of people, irrespective of their earnings, but then if they earn above 4K, then they are actually not allowed to claim overtime. That is spelled out in paragraph 1A of the first schedule. They are not allowed to claim overtime. That is mentioned there, section 60A, subsection 3. That is overtime. As such, they are covered under Employment Act, and so the limit of 12 hours also apply to them. So I make it very clear to you that the limit of 12 hours apply to them. Apply to them.
I see. Okay, this one interesting. What is the limit for paternity leave? Up to 5 children for paternity. Paternity leave ada limit lah?
Yeah. Ada. Up to 5 confinement, meaning
5 saja.
5 only. 5 confinement, 5 deliveries of the wife. Yeah. Yes, that is the limit of the paternity leave. So
and then if the wife beranak today, does it count from the date of today or tomorrow?
Yeah, the law is silent on that, but to me, it is talking about 7 consecutive days. So it must start from the day the wife give birth, the day of the confinement.
I see. Okay, sir. Okay, this one is about forced labor. If we don't allow the estate workers who stay within the estate to go in and out of the estate without valid reason, is this considered forced labor?
Yeah, forced labor including confine them in a place, restrict their movement. So as long as you confine them in the workplace, prevent them from leaving the workplace to go out of the estate, then this is forced labor.
Just for the information of the participants, we have uploaded a couple of videos, our project with the ILO Safe and Fair program, which details a lot about these aspects of forced labor, what to do and what not to do. So if you are free, then maybe you can access this video and maybe like and subscribe our MEF YouTube channel too. Okay. Under the flexi work arrangement, can an employee request for compressed work week or reduced work hours, which differ from the letter of offer?
Yeah, the flexible work arrangement is to, is for the employee to apply. So the employee can apply, can request for a compressed work week. Yeah? Compressed work week is meaning that in 1 week, they work, let's say 45 hours in the 1 week, but they work only 3 days. Example, they work only 3 days. They compress into 3 days, the 45 hours. Or reduce the work hours, which differ from the letter of offer. Yes, they can reduce the work hours that different from the letter of offer as long as they apply and employer approve. It's for the employer approve. If the employer do not approve, then employer have to give grounds. But your basic question is, can request for compressed work week? Can, but subject to approval by the employer. Yeah, and if employer do not approve, then employer got to give grounds. Here I have to explain to you that normally compressed work week is applicable to shift workers, not for those working normal shift normally. Yeah. All
So,
right.
Mr. Goh, there's another question here. Is a maintenance engineer categorized as a manual labor?
All right, that is a very interesting question because the word engineer is there. And knowing that the engineer is educationally qualified and professionally qualified, then in this case, is he a manual labor? As I told you earlier, a manual labor is one who involved in manual work, is one who involved in work using excessive physical energy. It does not talk about his educational qualification. It's not talk about his nomenclature, dia punya jawatan, nama jawatan. No. It depends on nature of job. There are cases whereby they are engineers, electrical engineers, but the court rule that they are manual worker, such as they repair television, they carry television. You know, those times are old cases where televisions are so heavy that they do it manually. Yeah. So they are
Those days,
ruled
Mr. Goh, our time lah. Nowadays, all very small, the TV.
Correct. Very bulky one, very heavy.
Yeah.
They do manual work. Yeah. And another example is that, you know, you have, for example, aircraft repair. They repair aeroplane. They are engineers, but they repair aeroplane. They do manual work. Yeah. They carry tires of the plane, you know, they unscrew it. They are actually 5 figures earning per month. They are called manual labor.
I see. Okay, Mr. Goh, this is another interesting one. Would JTK has the right to intervene if flexi work arrangement application is rejected by the employer and the employee is not happy?
Yes.
So it can.
Yes. When the employee apply and the employer reject, employer got to within 60 days reply to reject and give grounds. And when employee is not happy, he will complain to the labor department, and the labor department would investigate. Then they will interfere. Yeah. Right.
So the employer does not have the absolute last word lah. In this case.
Still
I see.
subject to investigation. And on this matter, on FWA, flexible working arrangement, the Labor Department will come up with a regulation as to the guidelines as to how to handle the application for FWA by employee. Yeah, so they will come out with a guideline. Yeah, employer will be complying with those guidelines in approving. All right.
Okay. For paternity leave, if the wife miscarriages, is the husband still entitled to this leave? Kena miscarriage.
All right. Very interesting questions. Yeah. Now, paternity leave, 7 consecutive days. Married man is entitled after working for 12 months with the company for the wife's confinement. And the meaning of confinement is delivery of a child. The meaning of confinement is for each confinement, for each delivery of a child, whether dead or alive, whether it is miscarriage or not, the man still entitled to 7 consecutive days, 7 consecutive days of paternity leave, even for miscarriage. But the birth of the child, whether it's miscarriage or not, must be, after at least 22 weeks of pregnancy. After at least 22 weeks of pregnancy. As long as after 22 weeks, she deliver and miscarriage, the husband get the 7 days of paternity leave.
Okay, Mr. Goh, I've been warned that we only have 5 minutes left. So maybe we can ask this last question. It's a bit more interesting. If a married male employee has 2 wives,
all right,
who delivers his 4th and 5th child on the same day.
Mhm.
Is he
Alright.
entitled to paternity leave for 7 days or 14 days?
Oh, this is something very unfortunate for the husband, where two wives deliver on the same day. The reason is the entitlement to paternity leave is 7 hari berturut-turut, dikira dari tarikh bersalin, counted from the
see.
date of birth. So it coincides the 7 days. So on the whole, he gets only 7 consecutive
Oh,
days.
tak boleh kali dua. Also, although he has 2 wives, also cannot.
Cannot.
Because
For the first wife A, 7 consecutive days from the date she gave birth. For the second wife B, also 7 consecutive days from the same day.
I see.
And it so happened if the 7 consecutive days ada 2 hari cuti am di situ, ada 2 hari rehat, rest day, yeah. So 4 days off already. He has only another 3 days.
I see. It's consecutive.
Yeah.
I see. So they can only split lah. First wife, second wife, 3,5 hari lah.
Kena
Dia
do
tak
some
boleh
planning
7.
lah. Planning.
I see. Okay, Mr. Goh, thank you very much
Welcome.
for sharing with us. For those of you who want a copy of the slides, you can call our membership section, which is in the comments box, and get a copy of your slides. And we look forward to seeing you again. This is our first YouTube live session, and we hope to have many more of these sessions. And we thank you for participating. Thank you very much.
Thank you, ladies and gentlemen, and thank you, Encik Zakri.
Thank you, Mr. Goh. Thank you, Puan Haslena. Thank you, team.